Can you please summarize the Supreme Court ruling on the Patient Protection and Affordable Care Act?
Yes, there were essentially two issues that were before the Supreme Court. The first was whether the individual mandate was constitutional and under the Commerce Clause, as originally argued, and then whether Medicaid expansion was constitutional as well. And essentially what the court decided was that the individual mandate was constitutional not under the Commerce Clause, but under the Taxing Clause, and that the Medicaid expansion as presented was okay, but what Congress could not do was hold states hostage for Medicaid contributions from the federal government, and so that the feds could not withhold Medicaid monies for failure to expand.
So on what grounds did the Supreme Court uphold the individual mandate and then strike down the Medicaid expansion specifically?
So we talked a little bit about the Commerce Clause. What the Commerce Clause says is that Congress has the authority to regulate interstate commerce. And so the argument within the Supreme Court that the individual mandate was unconstitutional was that the Commerce Clause would require some action in order for Congress to regulate it. And this was action, but it was involuntary action, or not involuntary action, it was mandated action. And so the fact that the Commerce Clause cannot regulate or mandate action, there has to be some involuntary act by somebody, the Supreme Court came along and said that the Commerce Clause was not sufficient authority for Congress to initiate the individual mandate. However, they could force the penalty associated with individual mandates. So if somebody chooses not to have health care insurance, Congress has now set up a penalty which the Supreme Court viewed as a tax that could then be assessed under the Taxing Clause. So Congress did have authority to penalize individuals who chose not to engage in this activity, in which case is to purchase health care insurance. From the Medicaid expansion, what the Medicaid expansion was trying to do is expand Medicaid beyond the women and children and elderly provisions that it is right now into folks in low income, so that Medicaid coverage would now cover those folks that fall under a certain level of the poverty level. And in enforcing this, and because it is a joint, Medicaid is a joint state and federal program where the feds take on 50% of Medicaid funding and the states take on the other 50%, in order to entice states to expand their Medicaid programs, the federal government said, if you refuse to, or Congress said, if you refuse to expand your Medicaid program, we will ensure that the federal contribution is no longer for you states. And what Justice Roberts' opinion said in the majority, which was really a 7-2 majority, what the opinion said was that essentially that was a gun to the head of states, that if the feds were going to take away all of their funding, which was half of the program, states could no longer have Medicaid programs. So there was really no choice in the states, and that was not sufficient under congressional authority. So separating that federalism from the state action.
Why was the ruling so widely expected to go the other way, particularly on the individual mandate?
Yeah, I think there were lots of reasons for that. I think folks were focused on the Commerce Clause especially, because initially that was the focus of Obamacare, is that under that individual mandate, Congress was stating and the President's administration was stating they had authority under the Commerce Clause to effectuate the mandate. So when you look at the Commerce Clause and the way that it's been interpreted for the past probably 20 years or so, starting with Justice Rehnquist when he was Chief Justice, it's been interpreted very narrowly to have very specific requirements. And so constitutional scholars looking at that individual mandate and under the Commerce Clause would have said, no, not under the narrow interpretations that we've seen will this be upheld. And what is interesting is that the surprise was that there was another congressional authority, the Taxing Clause, that created the ability to find constitutionality within the individual mandate. You'll find a lot of scholars who say that what the majority did, the majority of the court in this case did, was actually kind of rewrite the law in order to fall under that taxing authority. And what's really interesting too is that initially the Obama administration vehemently denied when the law first came out that this was a tax, because folks were calling it that. Those individuals that opposed the law were calling it a tax, and initially the argument was, well, it's not a tax, it's not at all. And so the very thing that the administration tried to avoid at the beginning became its saving grace with the Supreme Court decision.
Why was Chief Justice Roberts' position in particular so surprising or confusing?
I think that the court has become very, at least to outsiders, very politicized, whereas it's supposed to be a neutral body where politics don't matter. But when you get appointed by Republican or Democratic administrations, you are viewed as conservative or liberal on the court. And traditionally, what you've found in the current makeup of the court is that you have one certain swing vote, and that's Justice Kennedy, and a potential swing vote in Justice Alito. And generally, decisions that have come from the court would fall under what would be expected under their political appointment. So the more conservative judges are falling under the opinion that would favor the conservatives, whereas the more liberal judges, the Ginsburg, Sotomayor, Breyer, and Kagan, would fall under the more liberal interpretation and more federalist view. So Justice Roberts has been seen to be clearly in the conservative court. But what he did is really come out and say this isn't about politics. And he said when he was appointed as Chief Justice that he would be a justice that was neutral when it came to politics, that you couldn't expect, what you could expect him to do was protect the Constitution and to rule in a way that didn't suggest politics. So he really somewhat solidified his legacy here. But I think folks really that look at the court and say you can really hedge your bets based upon the political appointments were surprised because he didn't fall in line with the expected conservative view.
Now, there was another clause used in support of the individual mandate, the necessary and proper clause. What did the courts find with that particular clause?
Well, the necessary and proper clause is usually used in context with the Commerce Clause. And what the necessary and proper clause is that Congress has the authority to do all things necessary and proper to effectuate their laws. And typically that is seen in conjunction with the Commerce Clause. And so when you take away the Commerce Clause, the necessary proper clause alone doesn't give them the authority to pass any laws. It has to be in conjunction with some other authority granted to Congress in the Constitution. So it really didn't come into play.
While the majority of Americans have expressed disapproval of the individual mandate, many provisions of the PPACA are quite popular. Why is the individual mandate so unpopular, and what are some of the other more popular provisions of the law?
I think the individual mandate is unpopular because people believe that people just don't like the government telling them what to do. You know, even regardless of your political party, you still don't really enjoy having, as some folks would say, the big brother aspect of this is what I expect you to do as government. Nobody likes to be taxed generally, unless I guess Warren Buffett does a little bit, but generally nobody likes to be taxed, nobody likes to be involved in being told what to do. So I think that's why it's unpopular, and I think there's also general fear about what that will do to healthcare costs, whether that is justified or not. It's just a general misunderstanding or misinformation about what the individual mandate is. I think the popular things are things that, again, don't involve the government telling us what to do, but rather increase our ability to have coverage under healthcare. So the removal of pre-existing conditions, you could look at the popular provisions to be those things that really seem to suggest insurance companies aren't that popular. So insurance companies that would otherwise deny pre-existing conditions can no longer do so. Insurance companies that would otherwise deny coverage to adults, children who are unmarried and living at home cannot do that anymore. So those are really the kind of the popular things.
As implementation of the law moves forward, what could the law achieve according to such factors as healthcare cost, quality, patient and physician satisfaction, and technological advances?
Well, I think it really furthers where Congress started in 1996 with the Kennedy-Kassebaum Act and the Health Insurance Portability and Accountability Act. I think it really promotes the idea of health information exchange in a meaningful way. In 1996, it was new in the age of the internet to most Americans, and there was a lot of fear about what would happen if there was meaningful health information exchange and what that meant to privacy, hence HIPAA under the Kennedy-Kassebaum Act, and the regulation of privacy. And I think we've come a long way then in making sure that there are parameters and security and privacy involved in any health information exchange. I think the other thing the Act does is really promote innovation and promote the shift from volume-based to value-based care. Under traditional fee-for-service medicine, what are doctors rewarded for? Or what are providers rewarded for? Or facilities rewarded for? They're rewarded for the services that provide, fee-for-service. So the more services you provide, the more fees you attain. Under the shift that's been occurring even without the Act, but under the shift to value-based care, this really heavily promotes that innovation and that shift by creating things like the ACO projects, by having the Centers for Medicare and Medicaid Innovation that really is focused on ways to bring about that behavioral change that has created a crisis in healthcare and really in government spending.
What are the next steps now that the law has passed this initial legal hurdle, and how will private companies be involved in these next steps?
I think with private companies, and we already see it happening, I think folks, innovative companies that really believed that the direction was clear regardless of whether these provisions of the law were upheld, have already started this process and this finding ways to support innovation and supporting the tide change and the behaviors that need to change within healthcare. And how do you get information, and how do you have meaningful health information exchange? How do you get information to payers and providers and patients that suggest a more quality-based, outcomes-focused care? So I think that's really where folks are getting involved, and we're really seeing a big push to that now, but the true innovators have been involved in that all along.
Members of the GOP have stated that they will repeal the PPACA if elected. Could a GOP president and/or Congress repeal the law, and if so, how?
I think anything's possible. I think it would be difficult to do. It's one of those things where the stars have to align, and there are a lot of knowns and unknowns. I mean, we've already seen the House, who days after the Supreme Court decision came out, voted to repeal the Act. So under our system, that then goes to the Senate, where we're certain that will not pass because of the makeup of the Senate. So a lot of moving parts here. You have to look at what the presidential election would be. Presidential election alone is not, so if a Republican gets into office, then that isn't enough to repeal the Act. So then you have to look at what's the congressional makeup and what seats are in play and in the House and what seats are in play in the Senate. And if you get a majority in Congress and you have a Republican majority in Congress and you have a Republican in the House, seems like a done deal, but it isn't always that simple either. I think then you have to look at what the process for repeal would be and how that interacts with budgetary processes. I mean, the first order of business of a new Congress is always to set the budget, right? And elections in November, you come in January, or setting the budget for the year, and you have to have some compromises there, and things, as we have seen in the past, can get really difficult if there is a particular piece of legislation or particular law that folks are wanting to protect. So I think anything is possible. I think there is certainly a lot of momentum on the Republican side to fuel this idea that it can be done, but I think it would take longer than folks anticipate. And I also think there's been a lot of investment on the industry side to move towards the good things, or that's somewhat of a subjective, but the really unquestionable things in the law. The things that folks agree upon. We need to reduce healthcare costs. How do we do that? By moving to value-based care. Those things, there's been so much momentum around those and so much investment in those already that regardless of whether or not the law is repealed, that activity will continue.
Excellent. Thank you very much, Gail, for your time.